vaccine adverse bereaved and reaction groups. These three groups are the UK CV family, the Vaccine Injured and Bereaved UK, and the Scottish Vaccine Injury Group. You will hear powerful evidence from Kate Scott, Charlotte Crichton, and Ruth O'Rafferty on behalf of these three groups during your inquiry. The thousands of people that these three groups present what is an uncomfortable truth for many, that vaccine injury and death are part of the pandemic story. These are men, women and children who are otherwise healthy, who followed public health advice and voluntarily attended to receive their vaccine. They include doctors, healthcare professionals, carers and parents who accepted the vaccine thinking not only of themselves but of their patients and those who they cared for. Those I represent are neither anti-science nor are they anti-vaccine. They are real people with real experiences. And my lady, this inquiry must recognise and acknowledge the real experiences of the vaccine injured and bereaved and their need for real treatment, real care, and the need for real change in the way that vaccine injuries are reported and addressed. For too long, they've been ignored by the government, public health bodies, and the media. The COVID vaccine adverse reaction and bereaved are not just an unfortunate statistic or collateral damage to the government's vaccination strategy. They are individuals and families calling upon the health service and the government for urgent help. So, my lady, what does the inquiry need to understand about COVID vaccine adverse reactions and bereavement in this module? First, the inquiry must understand the decisions that were made around the production, regulation and rollout of the COVID-19 vaccines. The groups I represent question what was a so-called acceptable risk of the COVID-19 vaccines to them. And were those risks communicated in an effective way, which meant that members of the public were able to provide informed consent to vaccination? There was clearly a political drive for the UK to be seen at the forefront of global vaccine development, and we asked the inquiry to interrogate whether political pressure created an environment in which the assessment and the regulation of the safety of vaccines was not as robust as it should have or could have been, or whether a focus on vaccination meant the alternatives, such as therapeutics, were overlooked. We understand, for example, that the inquiry will hear evidence that the UK government agreed to pay AstraZeneca in advance for the supply of a potential vaccine, and that the government also agreed to indemnify them and the other pharmaceutical companies, such as Moderna and Pfizer, in respect of any losses from certain third-party claims. The purpose and the impact of this indemnification needs to be fully understood. Was this standard practice? Or was this a recognition by the government and the pharmaceutical companies that there was a safety risk in the development and distribution at such speed, which required special indemnification? The COVID vaccine adverse reaction and bereaved groups also want to understand the data available to the companies from their clinical randomised trial data and how this information was presented to the UK regulators. Where vaccines were scaled up from those tested in clinical trials, were the regulators presented with accurate safety data for the products that were in fact rolled out to the public? We also ask how did the MRHA and the JCVI scrutinise data, particularly with regards to those who commenced but did not complete the trials? Second, my lady, the inquiry must understand the post-rollout surveillance and monitoring of the vaccines. Although the desire for a vaccine at speed may have been understandable, the fast-track process for the development and rollout that followed meant that the stringent post-authorisation surveillance and monitoring was essential, as was public education and information on how to identify and report any adverse reactions to the vaccine. Essentially, the vaccine rollout put everyone in the UK in a Phase 4 post-authorisation trial. We were the real-world data that Mr Keith Casey referred to this morning. This made it imperative for the government and the NHS to ensure that there was an effective system in place that was well organised and signal sensitive to monitor, detect and treat any adverse effects. My lady, adverse reactions were to be entirely expected. As acknowledged by Mr Keith King's counsel this morning, any statistical probability on a population level of serious side effects such as thrombosis, thrombocytopenia, myocarditis, Guillain-Barré syndrome and other serious hematological, neurological, immunological and musculoskeletal injuries does not undermine their severity when they occur to individuals. Therefore, it must have been clear when rolling out the vaccine to millions of people, if the planning assumption was that 75% of the population were to be vaccinated, that there were likely to be vaccine-related deaths and serious vaccine injuries, however rare on a population level, that would require urgent identification, treatment and care. Many of us were vaccinated by our GP or our local healthcare provider. The BMA estimates that in England this was by over 70% of those vaccinated. We ask, were GPs also provided with sufficient information and training in relation to how to spot and report vaccine injuries? Many of us were vaccinated in mass vaccination centres and received multiple doses across different settings and from different manufacturers. We ask, were those who were vaccinated and vaccinating always advised of the latest information surrounding known risks? Was the patient information leaflet always up to date and available to those being vaccinated? Where changes were made to a safety profile, the inquiry must question whether public health messaging was early enough or clear enough in order that individuals could properly assess the risks to them. Also, was there a full understanding of whether multiple doses would impact of any risk of injury or further compound any existing vaccine injury? As Professor Stephen Evans points out in his written report to the inquiry, it could be said that safety is always provisional, in the sense that with rare events it may take some time to be detected. The logic to this statement is that vaccine risk assessment and risk management must retain an open mind to the occurrence of adverse events. What Professor Evans calls the degree of an individual or a system's index of suspicion. Our groups question whether the UK government, regulators and the NHS had a sufficiently high index of suspicion to identify vaccine-related deaths and to treat vaccine injuries when they occurred. For example, given that it was known that there would be adverse effects from the vaccine, some of which might not arise immediately, why were the public and healthcare professionals not alerted to the possibility of delayed onset adverse reactions or the potential for adverse reactions that are of an unknown nature? My lady, you've heard from those in the Impact film, and you'll hear from the witnesses from the groups tomorrow who detail the experiences of those whose vaccine injury symptoms were dismissed, ignored and misdiagnosed, sometimes resulting in catastrophic escalation of the injury or, in fact, death. It is likely that much of the inquiry's evidence from the government and public health bodies will highlight the yellow card scheme and the additional yellow card pathway introduced for the COVID-19 vaccines as the most effective way of identifying adverse effects or safety signals. But medical and emergency staff should have been given training and directives requiring them to identify any conditions arising after vaccination and to immediately report them. This would have been crucial both for ensuring appropriate treatment and for collecting data on emerging side effects. For example, why was there no guidance stipulating that medical professionals should ask patients who attended hospital or a medical appointment with new symptoms whether they've been recently vaccinated, similar to the way in which questions are routinely asked about smoking, other medication and drug use as part of a standard health examination? Those in our groups have experienced disbelief and sometimes hostility by medical professionals when reporting their symptoms. Doctors and coroners have refused to accept that injuries or deaths were caused by the vaccine. Suddenly losing a loved one following a, quote, safe and effective vaccination is a massive trauma. Then being told that the cause of death is not related at all to the vaccine adds indescribable distress. Members of our groups continue to fight for the true cause of death to be recognised, leaving them unable to find closure over the loss of their loved ones. But we say the problem goes further than a lack of training or a lack of suspicion. The inquiry must have the courage to examine how the public messaging, narrative and the context of the vaccine rollout created a hostile environment for the reporting of COVID vaccine-related deaths and injury. The inquiry will recall the mantra, follow the science, from Module 2. In Module 4, our groups question whether that mantra and that mindset contributed to a culture of political and public pressure which dictated that vaccines were inherently good and that there would be no adverse reactions expected. My lady, scepticism and challenge are all valuable parts of scientific analysis, but sadly those within our groups were likely to be branded by those designing public health messaging as being anti-science or even anti-vax. The vaccines were consistently reported as safe, with members of the public being told in messaging, you must have them. Everyone's personal freedoms, ability to travel, go to work or to visit loved ones often depended on being vaccinated. The government also provided healthcare providers with financial incentives to maximise vaccinations within their communities. This must have contributed, even unconsciously, to a mindset that the vaccine must be delivered at all costs. The inquiry should be quick to identify any development of vaccine bias within healthcare settings which could have impacted on healthcare providers' ability to properly identify symptoms of vaccine injury. Within our groups, there are also numerous doctors within the NHS who had their own concerns about the vaccine, but were instructed to keep those concerns from the public, including their own patients. We should all find this form of cultural censorship deeply troubling. Thirdly, my lady, the inquiry must understand the stigma and censorship attached to the vaccine injured and bereaved and how that is preventing them from accessing the treatment and the care that they need. One of the biggest issues that they have faced up until this point is being stigmatised, discriminated against and censored when they've used their voices to speak about their experiences of bereavement or life-changing injury. Husbands, wives, mothers, fathers, sons and daughters who have been killed or severely injured by the Covid-19 vaccine. Each death or injury has placed considerable emotional and practical strain on families, with some members having to become carers, leave their jobs, lose their homes, rely on food banks and face many other devastating consequences. During the early months of the vaccine rollout, those who experienced adverse reactions found it nearly impossible to access information about the vaccine injuries in the mainstream media. When they were eventually covered, the stories were often framed with an emphasis on the rarity of such reactions, the safety of the vaccine, the millions of lives it has saved. Having been disbelieved by healthcare professionals and ignored by the mainstream media, those injured or bereaved by the vaccine turned to each other for recognition and support. They use social media to connect with each other, share stories and express their grief. A poll of all UK CV family members revealed that 74% had been censored when talking or posting about their adverse reaction to the vaccines on social media. One member of a group posted his experience on developing blood clots and other debilitating symptoms following his vaccination. His post was removed and described as false and harmful. Unfortunately, this censorship has continued years after the pandemic and into our engagement with this inquiry. YouTube removed a video featuring my legal submissions to you, my lady, on the 13th of September 2023. And despite requests for a thorough review, YouTube cited a violation of its, quote, medical misinformation policy as grounds for removal. Given the speed and novelty of the vaccine rollout in the pandemic, the UK should have created an environment in which safety signals around adverse effects could be spontaneously reported and data collected. It should have been recognised that when the yellow card system was not able to capture all the signals, that social media was a rich source of information and support for those concerned that they were injured. Instead, the strategy seems to have been deployed in relation to posts about vaccine bereavement or injury was just simply to remove them from social media, to silence their voices. There does not appear to have been any effective attempt by the government or public health officials to use social media or even traditional media to meaningfully increase awareness of vaccine injury reporting schemes or to offer support and access to compensation for those who had suffered. Could a reason for the rise in trust of social media have been that people were able to find information about the adverse effects they'd experienced from the vaccine at times when government and official sources were silent on these matters? The psychological and emotional impact of those suffering from adverse effects of the vaccine, coupled with the silencing and discrimination against them, is likely to contribute to future vaccine hesitancy if not adequately addressed by this inquiry. Fourth and finally, my lady, the inquiry must urgently address the inadequacies of the vaccine damage payment scheme. The government knew at the time of the vaccine rollout that very rare adverse effects of Covid-19 vaccine will only be observable when there had been a large-scale rollout. Therefore, it was clear, we say, that there would have been a need for an efficient system to address vaccine injury that could satisfy the moral duty of the government to act in a way that was just towards individuals who suffered a disability or death as a result of engaging in a government-run health protection scheme. The COVID vaccine adverse reaction and bereaved groups are clear that the VDPS is not fit for purpose. Their calls for urgent reform have been supported by parliamentarians in both houses and legal academics. They have highlighted the moral and social duty, underscoring the VDPS, and underlined the fact that if there is no reform, there are likely to be significant implications for vaccine confidence, something that Mr. Keith King's counsel recognised himself in his observations to you this morning, my lady. The DHC itself acknowledged in its impact assessment for the expansion of the VDPS to include the COVID-19 vaccines that, quote, all citizens gain from the knowledge that the government would award financial assistance if they were severely affected. My lady, you will hear tomorrow Some harrowing stories from those who've had to wait inordinate amounts of time to have their claims resolved, often only on appeal, causing significant and compounding further distress for them and for their loved ones when they need support the most. No one who has watched this morning's impact film can be left in any doubt of the level of distress that the VDPS rejection can cause to those who are vaccine injured or bereaved. Many individuals experienced severe injuries that required urgent and protracted medical treatment, sometimes taking months. It was only after this point that doctors would acknowledge or confirm that the injury was caused by the Covid-19 vaccine. Many of these individuals were only able to make an application to the scheme when they were well enough to do so. They then faced 18 months to 2 years of delays in processing their claim and receiving payment. Mr. Keith has touched upon the disablement criteria, but the notion of a 60% disablement criteria is not one generally recognised in UK personal injury law and is attributed to a pre-war pension scheme and industrial injuries. We agree with the evidence before the inquiry in writing from Duncan Fairgrieve KC that the current system is unfair, and we say it needs urgent reform. It must now be clear that reform is urgently required and the current system has not met the needs of the injured and bereaved. There have been promises made by the previous and current government to look at the VDPS, but here we are 4 years after the first vaccination, and there has still been no action taken. My lady, your inquiry, like the many others before it, will be judged on the implementation of its recommendations. The imperative for you, therefore, my lady, we say, is to assist the effective implementation, is to thoroughly investigate the evidence with a view to making urgent, clear and meaningful recommendations, we say via an interim report, combined with a robust monitoring framework to deliver the long-awaited support to those who have suffered and those who continue to suffer the adverse effects of the vaccine. This will not wait until 2026 or 2027. Action is needed now. Importantly, as Mr. Keith acknowledged this morning, effective support and care for the vaccine injured and bereaved is inextricably linked to vaccine hesitancy. If the status quo is allowed to continue, public confidence in future vaccination programmes will be affected, as those that are asked to engage in vaccination can no longer have the confidence that there is any effective safety net for their physical, mental health or financial needs should they need it. In conclusion, my lady, of course, the groups I represent are grateful for being granted participant status in this inquiry, but our simple presence at this inquiry is not enough. What we trust the inquiry will hear loud and clear from these submissions and those we have made on previous occasions is that the voices of the COVID vaccine adverse reaction and bereaved will not be dismissed or ignored. Their experience with Every Story Matters and the report that's been produced has not given the vaccine injured and bereaved groups confidence that the inquiry has yet fully understood their lived experience. But we hope that Mr. Keith's words this morning reflect the inquiry's ability to listen during these evidence hearings. The inquiry must now listen to their voices and reject the stigma that has so far been attached to their stories in order that the truth can be acknowledged. Only then can the inquiry propose meaningful change to benefit future pandemics. We raise significant questions and make substantive proposals, which we ask this inquiry to break with the failures of the past and demonstrate what can be achieved by way of recommendations when the bereaved and injured are listened to. My lady, those are the opening submissions on behalf of the COVID vaccine adverse reaction and bereaved groups.
Thank you, Ms Morris. Mr Freeman, I think you're next. Are you right? Ms Freeman, I appreciate that the likes of you, Mr Thomas and Mr Stanton have all moved from top right to back left. I've asked if arrangements can be made if everybody's agreeable. So for those of you who are likely to ask more questions and therefore need to be closer to me and to the witness, to see if we can do some swapping around. So I appreciate it. Forgive me for the next 2 days, but that's the plan. Don't think so. No.
Yes,
got
you. Can
you.
Hear me now? Thank you very much, and thank you for what you just said, my lady. As you know, we act for Disability Rights UK, Inclusion Scotland, Disability Wales, and Disability Action Northern Ireland. They are National Disabled People's Organisations, or DPO, run by and for disabled people. The inquiry is about to consider a narrative that the way in which government science and industry carried out pharmaceutical interventions during the pandemic is something that the UK did well. Whatever value is placed on that narrative, for disabled people, it is complicated by a tendency to judge success by non-disabled standards. It declares how pharmaceutical interventions allowed society to reclaim its normality without sufficiently acknowledging that there is a plurality of different norms or appreciating the features of the endeavour that were problematic for disabled people. As we set out in written submissions, the problems that disabled people encountered with vaccines were foreseeable, but too often overlooked because of the way government works. This has adverse implications for disabled people. Problems came to the fore because vaccine prioritisation decisions, particularly in phase 1, were not informed by the social model, and ethical reasoning did not play a significant role at all. In consequence, the rollout of vaccines initially failed to prioritise disabled people, especially those under 65 with learning disabilities, when prioritisation was due because of what was known about the risk of premature death to that category of population. Even when cohort 6 was expanded to include those categorised as having, quote, severe and profound learning disabilities, change was made without acknowledging that there is no generally accepted definition of this term. It was not consistently coded on the GP and other databases, and learning disabled people and those caring for them do not necessarily self-define that way. In addition, prioritisation categories did not fully embrace the care system. While there was consensus that frontline health and care workers needed to be vaccinated early, what was not recognised early enough is that the frontline labour force for disabled people overwhelmingly comprises unpaid carers, informally employed carers, and personal assistants who are not necessarily registered anywhere or identifiable by reference to deployable data held by the DWP or local authorities. As a result, disabled people who lived at home faced invidious choices about continued support by unvaccinated assistants. Conversely, if their carers also worked in care homes, they could sometimes be vaccinated long before the still shielding disabled person that they cared for. The approach to prioritisation was also not ethically robust because its laudable concern to save lives did not appreciate the triple jeopardy that disabled people faced during COVID. Not only one, that disabled people could die from the virus, but two, they could die or be seriously diminished in life expectancy because of lack of access to other healthcare or services. And three, they could otherwise experience inhumane levels of social isolation when confined to their home or if vaccinated carers were not able to safely access them. My lady, there may be counter-arguments, and I'm not trying in a short speech to rewrite a policy, but what is apparent on current disclosure is that this type of ethical discussion did not take place in government in a structured and transparent way, and it certainly did not take place with the involvement of DPO. Instead, the JCVI decided at the outset that it would not consider ethics. In practice, ministers deferred to their advice. Government resisted the moral and ethical advisory group's suggestion that there should be a published ethical framework. And that ethics group did not scrutinise the JCVI approach to prioritisation at any time until March 2021. Which brings us to the problems with accessibility. The DPO emphasised the need to think through accessibility from start to finish, from how to reach out to someone to become vaccinated, to what journey they will make to the site, what will happen there, and how they can be supported in their decision-making. What instead occurred was the operation of multiple barriers affecting communication, appointments, physical and environmental accessibility, all of which could have been avoided if policies were co-designed with disabled people. To mention just two areas. First, physical and environmental barriers for disabled people existed in accessing vaccination sites, with difficulties in leaving home at all without assistance, thereafter in reaching the sites and entering step 3. Once in the environment of the centre, there were queues and waiting, various risks of sensory overload, and for deaf people, the combined problem of no BSL interpreters and staff wearing opaque face masks. Second, disabled people who were cautious about taking a new and relatively untested vaccine enjoyed far less accessible information and communications to support them in both their decisions and the practicalities of getting vaccinated. There should have been heightened emphasis on accessible and effective communication from initial contact, followed up with supported decision-making, and an opportunity to understand the implications, if any, of the vaccines for pre-existing conditions. What disabled people got was singular formats for letters, briefings without BSL interpretation, deaf or hearing impaired individuals receiving phone calls, letters without braille were sent to those who were visually impaired, booking processes predominantly comprised online systems when it was known that disabled people were less likely to have essential digital access skills or internet access. In any event, websites were often not high contrast. There was inadequate, easy-to-read versions or telephone options for those unable to book online or who otherwise wanted support or further discussion. Our final point concerns those disabled people who, for reasons of being immunocompromised, either could not take the vaccine or for whom the vaccine would not be fully effective. We are told that this could be over 1 million people who have not been able to return to normal life and are still shielding. The incompleteness of the research and ethical discussions about the urgent need for alternative kinds of prophylaxis, such as antivirals and monoclonal antibodies, is one of the problems of everyone else, so to speak, returning to their normality. For the DPO, the situation is neither smart nor kind. There is no certainty that vaccines will work for any of us next time round, but until then, the political will of the crisis and the heightened market incentives for Big Pharma have gone away, and a sizable part of the disabled population have been consigned to exclusion. My lady, when pandemic inequalities became a major political issue, as they did later in 2020, disabled people did not enjoy significant recognition in that politics. New structures and policies were brought into being, but disabled people were not empowered as the co-designers of planning for the second wave and the vaccine rollout. The Disability Unit and the Minister for Disabled People could not be relied on to amend the policies in the design stage, and neither could anyone else in government. For the next pandemic, establishing why this was so and how things could be different is probably the most important thing this inquiry could do for the now 16.1 million disabled people in this country who make up 24% of its population. The module is an important case study. What many disabled people experienced was a relatively non-negotiable set of options with little agency in design and delivery, and a burden on DPO and others in devolved nations and the third sector to correct deficiencies after the fact. This is not how government claims it wants it to be. But after several modules of evidence, one must ask how to describe a system that causes patterns of repeated disadvantage on a widespread scale to a particular group of people. An unavoidable word for that system is discrimination. What to call this aspect of the way disabled people are governed is important, not because we are in a court of law, but because the inequalities of the pandemic response were not inevitable. They require more open and adequate reckoning with the choices involved and the changes that need to be made. Once again, the inquiry is about to see why.
Thank you very much indeed for your help, Mr. Friedman. I'm very grateful. That takes us conveniently to 3 o'clock, and I'm particularly grateful to all the advocates who are keeping to timing so beautifully. I shall return at 3:15.